Welcome to Partnered Up Business Law, Deals, and Dynamics.
Hey everyone, welcome back to an all-new episode of Partnered Up Business Law, Deals, and Dynamics with Jeff Fink, a partner over at Coren Lichtenstein LLP out in Massachusetts. I am your host, Mike Leon. You know, Jeff has been advising business owners and partners on their business formation, growth, and dispute resolution for closely held companies. Today's episode, we're going to continue our part 2 discussion about LLC operating agreements. Jeff's going to break this all down for us. And Jeff, it's good to see you as always. So let's continue the conversation of what we were talking about from part 1. How do the operating agreements themselves, how do they deal with the management structure? Like who's calling the shots? How much protection do people have? All of that. Break that down for us.
So first off, thanks for having me again. It's recording this in the wintertime right now, so I'm seeing big piles of snow out my window, and Mike's down in Florida, so he's not seeing that. So it's good for you. Again, we started talking about some of these issues in episode 1. If you haven't had a chance to go and listen to that, it's worth listening to, just because it's really the first half of an LLC agreement and a lot of the really important economic stuffs. I do want to give an overview of things today. A lot of these topics may need a full episode in themselves. In fact, some of them we have, which I'll make reference to when we get there. But kind of the big picture question here is, what's an operating agreement? Why have it? What goes into it? So, Mike, the first question you asked was management issues. So who's running the show? There are two different kinds of LLCs. There's something called a member-managed LLC and a manager-managed LLC. A member-managed LLC is kind of what it sounds like. You're all partners. You can all do everything with whatever limitations you put in. Manager-managed LLC, you really delegate the authority to somebody called the manager, managing partner, or we wouldn't call it managing partner, managing member. You can have a board of directors and officers if you want to emulate a corporate structure. So a lot of ways to deal with that. There's a lot to negotiate here. We usually make suggestions for people based on our understanding of their business, but it's all really flexible. That's really one of the key concepts of LLCs is you have a lot of flexibility. Yeah. Most of the time, if you don't say anything, you're going to have a member-managed LLC. So if you want to restrict what people can do, you want to have somebody who's actually running the business and maybe somebody who's less involved, or somebody who may be involved but is only a minority owner, and you don't want them to have as much control, then you need that operating agreement to make that work. Lots of questions. First one is, how much do managers control? Are there limits to what they can do before they have to come back to the members and ask permission? Do you have, like a board of directors and officers, if you want to follow that structure, do you have specific manager type people who do different things? It's an issue both in operating entities and in financial investment vehicles. Who's running the show? Who calls the shots? You do want to specify protections for non-managers. Some of these protective provisions, they're kind of the same ones we see in stockholders agreements too, like approving the sale of the company's assets. You don't want the manager to be able to do that on their own. Maybe issuing new equity, though you don't really issue equity in an LLC, you admit new members, but maybe admitting new members is something that the members get to sign off on. Creating new classes of members. A big one is approving transactions between the manager and related parties. So if you have an agreement that says the manager controls everything and can do everything they want, they can hire their brother-in-law at an inflated price to do stuff, and you may not want that to happen. So that's actually a big one, and that's something that comes up in litigation. Those kind of related party things. We talked about can you delegate authority to officers? Doesn't really come up in financial investment vehicles, but does in operating companies. What happens if a manager, if you choose a manager manage LLC, what happens if a manager resigns or if they die, if it's an individual? Are there ever circumstances where the members can replace the manager? I mean, obviously, in those situations where you don't have one, you want somebody appointed. But what happens if a manager was doing something that you'd consider cause for termination if they were just an employee, embezzling money? So your agreement probably should address that. It's usually a member vote of some sort that lets you do it. And if you need a member vote, how's it run? Is it majority vote, supermajority vote, which you have to spell out what that means? Is it 2/3? Is it 3/4? Is it unanimous? Is it majority vote that includes some specified member? It's usually somebody with a preferred interest that put in some extra money. There are lots of variations on that, and again, it's all to be negotiated.
Jeff, there's a lot there. We talked about, though, in the last episode about the money and how money is the most important thing here. Can we talk a little bit about how transfers and withdrawals typically are handled within these operating agreements? I'm sure that's something that gets brought to you, like, right? Who is there limits on withdrawals? Who has the right of first refusal? Break that down for the audience.
I guess when we talk about withdrawal, we can mean two different things. One is, can you get the LLC to give you money back? Can you withdraw money from it like a bank account? Usually the answer is no, but sometimes people put that in. They can take out up to a certain amount. Oftentimes, these kind of situations come up when somebody just wants to leave, but they want to transfer their ownership interest because they found a buyer, or they don't like the people that they're in partnership with, and they want to get out, or the other partners want to make them get out for one reason or another. There's this legal concept called, you learned it in first year of law school, that an absolute restraint on alienation is prohibited, which means you really shouldn't say you can't ever transfer this, period. Usually these agreements will say you can't transfer except with somebody's permission, whether it's a managing member or whether it's permission of the other members, unless you follow certain steps. There are usually, but not always, exceptions for that let you, if you're a corporation or some other entity that owns the interest, you want to be able to transfer it to your affiliates, move it from one subsidiary to another. If you're an individual, you might want to be able to move stuff around for estate planning purposes. So maybe your heirs get it. That's a question we'll get to in a second. Maybe it goes into a trust. Maybe it goes into a family limited partnership or LLC. I would say 80% of the time that stuff gets permitted without having to go through a process. Then if you want to transfer it to a third party, you have these provisions called either right of first refusal or right of first offer. And maybe I was a fourth or fifth year associate when someone explained to me these things are so complicated that they make people negotiate most of the time. And I've seen that play out over the course of my career, but the provisions are in there and you have to comply with them. What a right of first refusal is something that says, okay, you found your buyer, you have the terms of your deal set up, agreed with them, and then you have to offer that same deal to all the other members. Maybe first to the company if the company wants to buy back your interest, and then to all the other members. One of the problems with that is that the buyer will have had to do a lot of due diligence. They'll have had to put documentation together. They'll have incurred a lot of time and cost to get to that point, and then have the company swoop in or the other members swoop in and take it away from them, and then not get compensated for it, for the effort they put in, is a disincentive. That's a good word for people to go through that process. So that's why they'll often not always, but often try to negotiate something upfront about it. A right of first offer is a little different. It's where you're a member and you say, I'll sell all my membership interest to the company or to the other members for $100 and on these terms. And if you don't want to buy them, then I can go out and sell it to anybody else for up to some period of time on exactly those terms. Probably see rights of first refusal more often than rights of first offer, but we do see both of them. Yeah, I mean, there's lots of detailed mechanics of how these things work, so they do go on and on and on in the documentation. But at a high level, that's what they are.
Mm.
Then you get to questions of, are there circumstances in which a member can get kicked out? Fraud, mismanagement, taking money, things that might things that would, if you have in a regulated industry, things that would cause the company to lose its regulatory license.
Right.
And you want that to protect the company, but then who decides? Is it the other members? Is it the managing member? To be negotiated. Okay, so then, we talked about rights of first refusal, rights of first offer, kicking people out. There are things called tag-along and drag-along rights that have kind of fun names to them. A tag-along right is if you're a minority owner and the majority owners sell, then you get to go along with them on the same terms. And you might have to pay your proportionate share of the expenses of the sale then, but at least you're not stuck there with a brand new majority owner and that you've never met before. A drag-along right is the flip side of that. Say you're a 10% owner and a bunch of other members are 90% owners and they decide to sell. And you think, well, if I hold on with my 10%, the buyer's going to have to buy me out and they're going to pay me a premium. Well, drag-along provision stops that. It says that if more than a certain percentage sells, they can make you sell along with them on the same terms. There's a mechanical question of how they work with rights of first refusal, and they'll often kick in if the members of the company choose not to buy in a right of first refusal situation. So it's going back to that. It's just it's an extra layer of complexity that really make people who want to buy in negotiate with existing members, and so that way you don't have a surprise guest sitting at the table.
Jeff, let me ask you about how does the operating agreements kind of address dissolving the business or winding it down or dissolving the LLC completely? How does it address that?
I guess really two to three questions there is who decides to dissolve it. It's usually a majority of the member, maybe the managing member. We'll talk about dispute resolution in a second, but judicial dissolution is always a possibility. If you're absolutely stuck and you can't get out, the courts will usually step in and help you separate things. There are these cases on something called manufactured deadlock that don't really do what they sound like they would. The courts will say, well, it's not no-fault divorce, but it's very rare that it's not a no-fault divorce if things get really bad. If you don't file your annual reports, your state will dissolve you. You can come back into good standing there if you pick them up. I once had somebody who hadn't been paying for 15 years and thought they had their business, but the state didn't think so. So we had to go back and file 15 years of annual reports, pay the Commonwealth of Massachusetts a lot of money for it. But that's one thing. So what do we mean when we talk about dissolution? It means a state filing that says the entity is closing down. And that way you get to file your final tax return and everything's over and done with. There's a term called winding up that people use, which means the process of shutting down the business. So how that works mechanically, you look at the state statute. If you don't have it spelled out in your LLC agreement, at least, some of them allow dissolution and then winding up. Some of them want most of the winding up to be done first. It depends on the state. who's responsible for doing the work? Generally, you appoint one person or two people as a liquidator or liquidating trustee. Sometimes that person's named in the operating agreement, but there's got to be somebody in charge of that. The order in which assets are distributed after you dissolve it's usually spelled out in the statute. It's actually always spelled out in the statute, but you can change that in the operating agreement. And generally, we suggest you do that for tax reasons. Too complicated to go into here, but you have to go back to that substantial economic effect concept we talked about in the last episode. In other words, be careful what you're doing actually works with the tax allocation provisions.
So, Jeff, let me ask you, because you mentioned before about dispute resolution. How do the operating agreements here usually deal with dispute resolution?
Usually they're silent, honestly. They'll say any dispute will be resolved in arbitration or it'll be resolved in courts. And since courts and judges and arbitrators don't really like making business decisions about things, the remedy for an intractable dispute might just be dissolving the LLC. But other than that kind of boilerplate stuff that says court or arbitration and choice of law, a lot of them are quiet about it. That might be the right answer. So as for court or arbitration, each one has its advantages and disadvantages. I've seen them both. They're both difficult processes to go through. So if you can find your way out of the box without having to go that route, you're much better off. So with court, you have better rules on evidence. You have a right to appeal, but it's slower because you're operating on the court schedule and they're really busy. There's some things that you might have a jury decide rather than the judge. Sometimes it's better. Sometimes that's worse. Arbitration can be faster, can be cheaper, depending on the lawyers and what they do with it, and also depending on the arbitrator and what the arbitrator lets them get away with. There's always a question of how much of the dispute is subject to arbitration, because arbitration is a creature of contract. So a lot of the times you'll have cases where there's a piece of it that goes to arbitration, the arbitrator makes a decision, and then the rest of it pops back into court. Goes on for a long, long time, very expensive. But again, if you're in arbitration, there's no right of appeal. There is a problem that people talk about with arbitration called splitting the baby, which is the arbitrator will look at people and, oftentimes in these situations where there's an issue that comes up and it's not just a simple business issue, both sides have done something, or their lawyers can point to something the other side has done that's not completely kosher. And you might have something really awful on one side and some little thing on the other side. And the arbitrators will go back to this concept of, again, quoting law school, to receive equity, you have to do equity. And they'll say, you both did bad things, or pox on both your houses. I'm either going to do nothing or I'm just going to split it. I'm not going to fine for either one. That does lead to an unfair result. The arbitration administration groups have come out with studies that say that doesn't really happen so much. I'm not so sure about it, having gone through a lot of arbitrations. In a 50-50 entity, there are not really a lot of other great ways to break a deadlock. You can have somebody who comes in with a tiebreaker vote. They're always really careful. They try to split the baby. It's a great idea. I've never seen it work in practice, but I write it into agreements if people want it.
Right.
You can have, the other thing is something they call a Texas shootout, which is, I don't want to be in a partnership with you. I'm going to put a dollar amount on the table, and either I'll buy it from you for this amount, or you'll sell yours to me for this amount. Right. And you set up a timetable for that, and there's a process for it. And everybody's terrified of that because everybody thinks, there are two different prices. I'll buy at one price, and, I'll buy if it's low, but I'll sell if it's high. You can't do that. Lots of other ways around that, but those are the main variations. Yeah. And I think we're going to have to do a whole episode on that because it's just too complicated.
There's a lot to digest with all of it, but you're a great resource of knowledge for everyone out there, Jeff. Thanks again for the time, the insights, breaking this down. Appreciate it.
Thank you, Mike. It's great to see you again.
And thank you to everyone out there for listening to this installment of Partnered Up, Business Law, Deals, and Dynamics. If you want to connect with Jeff, you want to learn more about Jeff and the team over at Coren Lichtenstein, do me a favor, visit cl-lawgroup.com to connect with them. And one more favor, as always, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
See you, Mike.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.